You're good now. Thank you.
Okay.
We're live.
Susan, over to you.
Thank you. Welcome to this virtual licensing subcommittee meeting that is being conducted with members, officers and members of the public at various locations communicating via Zoom. There is also the opportunity for the public and press and listen and view proceedings on the YouTube channel. Please note that the meeting is being live streamed and the recording will be available following this meeting on our YouTube channel. Before the meeting starts, I would like to confirm that members and officers are in attendance and can hear and be heard. So Councillor Ian Albert?
Yes, thank you.
Councillor Keith Hoskins?
Yeah, here, thanks.
Councillor Tim Johnson?
Yes, thank you.
Councillor Stephen Patmore?
Yes, I can hear you.
Lovely, thank you. And officers, we have Melanie Gillespie.
Yes, I'm here and can hear.
Lovely, thank you. Jasmine Jennings.
Here, present.
Simeo Paxo-Kaitu.
Present.
Present. And Alina Prader.
Present, thank you.
Okay, and then we have Alan Stone.
Yeah, hi. Good afternoon.
Okay, thank you. And representing the premises, we have Michael Curtis and Rob Scahill.
Hello. Yeah.
Okay, great. Thank you. Okay, to start off, we have to elect a chair. Can I please request nominations for the chair of this meeting of the subcommittee?
Councillor Ian Albert.
Okay, can I have a seconder, please?
Yep, I'll second that.
Thank you. Councillor Ian Albert is therefore elected as chair of this meeting, and I will now hand over to them.
Thank you, Susan. Welcome, everyone. So my name's Ian. I'm chairing the meeting today. Now we need to just to agree a reserve member that's obviously to listen and obviously participate in the hearing, just in case we have any further sort of IT problems. I'd like to propose that Councillor Stephen Patmore is our reserve member today. Could I have a seconder for that?
Yeah, happy to second.
Thank you, Keith. Stephen, if you're okay with that, we'll nominate you as our reserve member for the subcommittee meeting. But
Yep, I'm fine with that.
thank you. Welcome everyone. As I say, if you can sort of go on mute for unless obviously we're calling you in to speak. If we could then move to the hearing procedure, and if I can invite the committee clerk to outline the hearing preliminary, which is detailed on page 3 of the agenda. Susan.
The subcommittee will consist of 3 voting members with a 4th non-participating member listening to the hearing. In the event that a voting member loses connection, the hearing will adjourn until connection can be restored. If the adjournment exceeds 10 minutes or it is apparent sooner that reconnection will not be possible, the 4th member will replace the absent member and become a voting member of the subcommittee. If a quorum of 3 members that have been present throughout the hearing is not possible, the hearing will be adjourned to a later date. In the event that the applicant loses connection, the hearing will adjourn until connection can be restored. If it becomes apparent that reconnection will not be possible, the hearing will be adjourned to a stated date. In the event that another person that has been indicated their wish to speak loses connection, the hearing will be adjourned until connection can be restored. If it becomes apparent that reconnection will not be possible, the hearing will then be adjourned to a stated date. If another person that has indicated that they will not be participating orally in the hearing loses connection, the chair may decide to continue with the hearing. The subcommittee will undertake their deliberations in private and return to announce their determination on the live stream. However, they will not wait until all parties are connected. A copy of the decision will be forwarded to all parties electronically as soon as practicable. Are there any questions before we start the meeting? No? Okay, I will now hand back to the chair, Councillor Albert.
Cheers, thank you, Susan. So if we could kick off, if I could invite our legal advisor, Simeo Paxo-Kaitu, to outline the matters for consideration at the meeting. Welcome, Simeo.
I'm grateful, Councillor Albert. So this matter today concerns an application for a standard temporary event notice under Section 100 of the Licensing Act 2003. As a result of that, the committee is being asked to consider whether or not, following the objection, there should be any conditions imposed. The committee is obviously, and the panel is reminded that when it relates to temporary event notices, then the licensing regime is a permissive one, and the panel has to consider whether, if there are any conditions to impose, those are conditions which effectively reflect and promote the four licensing objectives. Those objectives being the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm, and that those conditions, or any conditions that you might consider imposing, would not be inconsistent with the carrying out the licensing objectives under temporary event notice.
Thank you. Thank you for that. Are there any kind of questions for the legal officer? If not, I can't see it. So if I could then invite the licensing officer to present any additions or amendments to the report. Mel. You're on mute at the moment, Mel.
Sorry about that. I was trying to do it on the headset, but it wouldn't work.
Okay.
So thank you. Good afternoon. There are a couple of amendments to the report due to a revision on the guidance issued under the 182 section of the Licensing Act 2003. In the report, in paragraph 7.1, the reference 215 is corrected to 2.21. The reference 216 is corrected to 2.22. Excuse me. In paragraph 8.12, the reference 2.38 is corrected to 2.27, and the reference 2.233 is also corrected to 2.22. I do have a couple of comments also that relate to the hearing. May I remind all parties that today's hearing and any contributions must relate specifically to relevant areas of their representation or an expansion of the points. New information not included in the representation cannot be introduced during the hearing. Discussions should relate to this premises location only. This process should determine how the use of the premises can be managed and what activities, if any, are appropriate in relation to a narrow consideration of the four licensing objectives. Any matters not relating to the licensing objectives are not relevant to today's hearing and must not be discussed or considered. Subcommittee is reminded that its determination today must be based on the specifics of this application. The subcommittee must assess the application, operating schedule, oral submissions of the applicant and assess whether it believes that this applicant can adequately promote the licensing objectives. Whilst the subcommittee should have regard to the fact that the application has satisfied other responsible authorities, the subcommittee is entitled to make further amendments to timings, conditions if it deems appropriate to promote the licensing objectives based on the oral submissions. If the subcommittee is satisfied that there are no appropriate times or conditions that will be adequately promote the licensing objectives, it is entitled to refuse the application. Thank you, Chair.
Thank you. Thanks for that, Mel. Does the responsible authority, that's Alan Stone, have any points of clarification for the licensing officer? Alan?
No, thank you, Chair.
No, thank you. And would either of the applicants, Michael or Rob, have you got any particular points of clarification at this stage for the licensing officer? No, thank you. That's great. And then, do any members have any questions at this stage for the licensing officer? No, I can see lots of shaking their heads. Thank you for that. So let's then move on to the applicant representation. So could I invite either Michael or Rob, or indeed jointly, to present your submission supporting your application? Over to you. Do you prefer Mick rather than Michael, or is it?
I don't really mind.
Whichever. Well, thank you.
Yeah.
But over to you, Mick and Rob.
Well, Rob's going to speak for me, so that's okay.
Fantastic.
Okay, thank you, Mr. Chairman. Just speaking on behalf of Mr. Curtis to start with, I've prepared this submission for you today, but I'm very uncomfortable in these situations. I have asked Mr. Scarl, the licensee of the Orange Tree, to read my submission and also that for my wife on my behalf. I've also asked Mr. Scarl to read his own submission to you to explain in detail the issue he is facing that has caused this counter notice to my temporary event notice. Please be allowed to answer any of your questions on my behalf. My submission, Mr. Curtis's submission, will take about 2 minutes. My wife's about 1 minute, and Mr. Scarl around 10 minutes. So, on behalf of Mr. Curtis, my wife and I approached Mr. Scarl at the Orange Tree some time ago about the possibility of hosting my 60th birthday party at his pub. We drink there regularly. I've been to quite a few events there. We find it an enjoyable, safe, and well-managed pub. We asked if we could have one of our favourite bands, the Dirty Half Hundred, play at the party, and to make it an afternoon to early evening affair with a barbecue and lots of our friends. Despite what the name of the band may suggest, the band are, as they describe themselves, a Hertfordshire-based band playing funk, soul, rock, rhythm and blues, and, well, a little bit of everything actually. They are great fun, very musical, and hugely entertaining. Following Mr. Scarl's agreement to provide the venue for us and also to provide food and drink, we booked the band and have invited 100 of our friends. We were made aware at the time that Mr. Scarl was still trying to agree with North Lancs District Council Environmental Health the allowable sound level limit condition for his premises licence, but at the time it was in hand and shouldn't be a problem. As the date of the event got closer, Mr. Scarl suggested that we'd have to apply for a temporary event notice, but otherwise he would be at the risk of breaking his licensing conditions regarding noise, and he made it clear that without this, we wouldn't be able to go ahead with the event outside. We really wanted to have the event in the marquee as it is such an amazing place for bands to play and exactly what we wanted for my party. So with Mr. Scarl's assistance, we went ahead with the temporary event notice application. We were devastated to receive the counter notice as we desperately want this party to go ahead with our friends and our favourite band in that marquee and garden. It's so much better than being inside. I ask you therefore to please carefully consider this and the statements from both my wife Fiona and Mr. Scarl himself, and allow us to go ahead and enjoy the Dirty Half Hundred on my 60th birthday party, the first party I've ever hosted, even at my ripe old age. That's the end of Mr. Curtis's submission. I'll now go on to the submission by his wife Fiona. I will say the second half of this submission is kind of circumstantial stuff about other pubs. I don't think it's relevant, so I'm not going to state it if that's okay.
That would be helpful because yes, it's not relevant to this this series. We're only specifically looking at this application and this premises.
Correct. Thank you, Mr. Chairman. So Mrs. Curtis said as follows: the points about the party. It's a 60th birthday party. The majority of the guests are over the age of 50. A very much family and very close friends party, and outside area will be restricted to just those invited. The younger people attending are all relatives of mine, some bringing their children, and are all responsible parents. I have lived in Baldock for 32 years. This is the first party I've had in a venue since moving to Baldock, particularly like the Orange Tree as a venue due to the size and security of the garden. I sometimes go to the Orange Tree at weekends and I'm very impressed by the control of the garden outdoors when it gets later in the evening. I've never witnessed any antisocial behaviour, so that's what she has said. Regards to the music, the event has been held on a Saturday, typically a non-working day for most, and we have stipulated on the invites that the close of the party is 9:30 p.m. to ensure people are out of the garden and music has stopped at this point. The music is intended to be in the marquee and not directly outside, which should reduce the joys to neighbours. I don't think we need to say anything else because the rest I don't think is relevant. And now over to me, I guess. This is my submission. Mr. Curtis has already covered why this temporary event notice has been submitted, but I just wanted to add the detail of how we got here and the challenge I personally face. At a full licence hearing in January 2021, some conditions were attached to the premises licence of the Orange Tree regarding the use of the garden and marquee for regulated entertainment, specifically live and recorded music events. The relevant sections in these conditions are summarised as follows. Number one, The installed sound limiter in the marquee needs to be commissioned and agreed with North Hertfordshire District Council Environmental Health prior to any outside events taking place. And number 2, the designated premises supervisor, myself, will draw up and implement an entertainment management plan. The plan will set out what measures will need to be in place to ensure that entertainment will not cause a public nuisance to residents in the immediate vicinity of the premises. I've been trying to get three-way agreement between ourselves, our neighbours and North Herts District Council for 3 years on what an acceptable sound level is. But despite writing to the neighbours, holding surveys, running test events and taking many readings at them, and also inviting North Herts District Council to attend the event to help us find this level, I've been able to make much progress. I even had Councillor Alistair Willoughby talking to those neighbours to get their views on weekend. It is only recently, with the arrival of a new environmental health officer, Mr Stone, who is present, that North Herts District Council has become more responsive to this issue, which is welcomed. He is the first, for instance, to meet our request as part of the process to come and take readings at a recent Baldock Festival event, Country Roots Baldock Boots, on the 5th of May this year, which incidentally was also covered by unopposed temporary event notice. The result of Mr Stone's visit will be discussed later in my submission. So as we stand here today, North Herts District Council Environmental Health and I have not been able to agree on what decibel level our events should not exceed, so we can then set the sound limiter and monitor other sound sources during performance, so that from the environmental health point of view, it is not too high to cause a potential disturbance, nuisance to our neighbours, and from our point of view, that we can successfully hold a live music event with a full band without a level so low that it negatively impacts the performance of the band or the experience of the audience. There are two things that do not help us in this matter, and it's not as simple as it seems to get to a point of determining what this decibel level should actually be. The first is that, in my opinion, there do not appear to be any clearly defined sound levels in any appropriate documented guidelines used by environmental health. Not just, it was seen by North Herts District Council, but from what I have researched, by any council. And it is not North Herts District Council's fault, because as I'm about to explain, this is a very complex issue. North Herts District Council, Environmental Health and others have been referring to two documents during this process. The first is the Code of Practice on Environmental Noise at Concerts, which was put together by the now defunct Noise Council in the 1990s. Whilst this document does contain advisory decibel limits, for instance, that music noise levels should not exceed 75 decibels average over a 15-minute period for 1 to 3 concert days per year for urban stadia or arenas, or 65 decibels in rural venues, and for all venues for 4 to 12 days a year, not exceeding the background noise level by more than 15 decibels. But also, it is stated on the 4th paragraph of the introduction to the code that this code is not designed to address the question of environmental noise arising from discotheques, clubs and public houses. I reiterate, the Code of Practice clearly says it is not designed for use in this scenario. The second document supplied by North Herts District Council Environmental Health is the Good Practice Guide to the Control of Noise from Pubs and Clubs, dated March 2003, and from the Institute of Acoustics. This document also does not contain any specific recommended decibel levels for us to work to, but it does contain a passage in the scope section that hopefully underlines why this is such a difficult task. It says, the original intention was to include objective noise criteria in this document that could have been used to access and control noise from all the main sources of noise that can be present at pubs, clubs and similar premises. However, it has not been possible to subject the new criteria that have been developed and proposed by the Working Party to a satisfactory validation process. And it goes on to say, until such criteria are developed, it is recommended that local authorities and others should devise and apply policies having regard to this guide and taking into account local circumstances and existing licensing and planning policies. So here we are. I have to submit an event management plan to be compliant with the conditions on my licence, something I am extremely aware of the importance of, by the way, but without agreeing the level for the noise limit to be set at, I cannot complete it. Mr Stone's view is that by using the limits described in the Code of Practice on Environmental Noise at Concerts, that the noise level should be limited to a mere 58 decibels in our neighbour's garden. It is my view that regardless of it being what I believe to be excessively strict or unfair, it simply isn't practical for us to have a live performance with such a restriction, and I will now explain why. The challenge that a sound engineer faces when we host live music outside, either in the marquee or the garden itself, is the nature of the instruments used themselves before any electrical amplification is used. Since the process to try and agree the levels began, I've been diligently recording sound levels, tweaking the locations of our speakers and analysing the way our sound system works to try and find a balance between giving the best musical experience whilst having the most compliant setup. The sound engineer's biggest issue is managing the sound that emanates from the one instrument in a live band that you have little control over, the drum kit. I've been a sound engineer mixing bands for nearly 15 years and have lots of experience in these matters when it comes to small scale venues. Without wishing to state what you probably already know, when a sound engineer balances the set for a gig with a live band, they start by balancing the drum kit to the bass guitar. These provide the glue that binds a live band together. And when the engineer will bring in other instruments in the back line, usually a lead or rhythm guitar and sometimes an electronic keyboard. Once these elements are balanced correctly, the engineer will then bring in the front of house microphones, lead, backing vocals, and any other mic'd up acoustic instruments such as wind or brass to a level that marries them with the rest of the back line to complete the setup. So any starting point for sound is therefore always the drum kit. And although it is possible to use sound limiting pads on the drum skins, it is invariably very difficult to do anything more to reduce the sound generated by a drummer. I quote, "A standard drum set ranges between 90 decibels and 130 decibels. This is incredibly loud compared to non-amplified instruments like acoustic guitars and pianos. If you play an acoustic guitar as hard as possible, you may be able to get it up to 75 decibels. And a standard upright piano is only around 70 decibels at its loudest. With drums, the smaller drums in a kit can be as quiet as 80 decibels, while loud cymbals, such as the crash, may be up to 130 decibels if you strike it very hard. At the Orange Tree, we reduce the drum sound outdoors by placing the kit inside one of our booths in the marquee as opposed to having it out on the stage. This reduces noise radiating from the sides, back and above the kit, and it also helps reduce those peaks generated by the cymbals. At the Country Roots Bulldog Boots event that I mentioned before, the Heartland Roots Band, I don't know why they name them like this, the Heartland Roots Band used a drum kit during their sets from 6:15 to 7:30 p.m. Although Mr. Stone wasn't at the neighbour's property during that time, we have his later readings to use as a reference. I mixed this particular set as low as I could to match the drums, with only the kick drum being mic'd up so that it could be relayed back through the monitor or foldback speakers. These are speakers that face the musicians to help them, amongst other things, to perform in time. As is usually always the case, the band had bought their own bass and guitar amplifiers. It is very difficult to convince guitarists that to use house amplifiers for their guitars, as they almost always insistent that the sound and feel from their specific amplifier is critical to the overall sound of the performance. We do provide some small 25 watt and 35 watt orange amplifiers, which we can mic up and put through the PA to give better control of the levels. But again, guitarists seem only to be comfortable with their own amplifier being behind them on stage as they play. We do possess an electronic drum kit, which obviously can be set to very low levels if necessary, but our experience from the early days of music in the marquee is that drummers simply refuse to use it, to the point that the band would just not play the gig at all if their drummer was forced to do so. We place the main front of house PA speakers to the front left and right of the marquee stage. Speakers must be in front of the band and especially vocalists for our PA system to avoid feedback from the vocal and other microphones. And we put two small slave speakers at the corners of the outer wall of the marquees to convey those vocals further into the audience, which negates the need to have the vocals louder in the main stage PA speakers. When monitoring the sound levels during the preparation and for the live performances, we use a point in the middle of the furthest distance from the stage that is still covered by the apex roof of the marquee. We use a handheld sound meter, this one, to take readings at 1.2 meters from the floor. From that position, I took readings during their performance, all of which are around but not over the 100 decibel mark. I also took a video of me walking, taking readings around the Sycamores, which is the back of the Orange Tree and the marquee, whilst the band were playing, giving me readings around 60 decibels outside numbers 38 and 39, the Sycamores, where our most vocal complainants reside. Obviously, I was unable to measure the levels inside their gardens. Mr. Stone was present outside the Orange Tree, presumably in a neighbour's garden, during the later performance from the Wild Wild West show, comprising of a singer with backing tracks and dancers. This took place between 8 and 9 p.m. My readings during the show, when Mr. Stone was also taking readings, were also at 100 decibels inside, equating to an average of 69 decibels as reported on Mr. Stone's device. My view is that an average level of 69 decibels for a performance, Mr. Stone's view is that an average level of 69 decibels is too high, and this is where we have an issue. If I can put this into context, 75 decibels is the sound of a toilet flushing. 70 decibels is about the same noise level you would hear in a normal conversation with another person. I am currently talking at about 79 decibels now. 60 to 65 decibels is the sound of general hubbub in a restaurant or office, and 55 decibels is the sound of a normal household fridge. I did as much as I could to keep the levels down to match the drums, but that 100 decibel reading on my meter, equating to what I expect to be the 69 decibel reading on Mr. Stone's equipment in the neighbour's garden, was about as low as I could go to give a reasonable sound from the band. Any less from the PA and the guitars would have been just too quiet. And trying to achieve what will give a 58 decibel limit level on Mr. Stone's equipment will mean a level of about below 80 decibels at our measuring point, which with a drum kit, it would exceed every time. It is simply neither achievable nor practical. My hope is that we can find a compromise here that is acceptable to all. And it is my belief that a level of no more than 70 decibels in the neighbour's garden, which equates to 100 decibels in the marquee at our monitoring point, will allow the music and vocals to be sufficiently high enough, not only for a sound engineer to marry the rest of the vocals and instruments to a drum kit, but for the sound levels inside the marquee to be loud enough to give an enjoyable experience for the audience. I reiterate that I believe it impossible to get the sound levels any lower when a live band with a drum kit is playing at any level of quality in the marquee without significant structural soundproofing work. This is something I simply cannot afford. I suggest that 70 decibels of sound in our neighbour's garden, again, about the same noise as normal conversation between two people, seems more than fair and reasonable. I would like to finish by asking you to please allow us to go ahead with this event so that we at the Orange Tree can use it as a test case to help us find a compromise with North Herts District Council on our sound limits. If we can find the noise level at our proposed limit of 70 decibels is not unreasonable for the neighbours, we could work with Mr. Stone to get some real benchmark data inside the marquee as well as in the neighbours' gardens at the same time to assist us in correctly setting the devices and levels to keep the sound generated in those limits. This exercise would help to solve all our issues, or at least give us both something to work on when discussing with the neighbours, who at the end of the day are the ones we need to appease. I would therefore ask this committee that you allow this event to go ahead. You allow us to use a maximum level of 100 decibels at the measuring point inside the marquees, so I can configure the noise limiter appropriately and thoroughly test it in a real-time live environment. I can then complete and distribute my event management plan, which I hope the proposed draft format is in your packs today. We think this is a fair, reasonable, proportionate, and most importantly, practical and achievable proposal that meets our desire here at the Orange Tree to make Mr. Curtis's birthday party all he wants it to be, whilst being totally respectful of our neighbours and helping us to go forward to achieve compliance to the conditions that are on the Orange Tree's premises licence. Thank you.
Thank you. Thanks for that submission. That's really appreciate that. So first of all, does the responsible authority, Alan Stone, have any points of clarification at this stage for the applicant? Alan?
Yes, please, Chair. Thank you. Mr. Scale, you mentioned a lot of stuff there. A lot of it was to do with decibel levels inside the marquee and what I measured. I've got diploma in acoustics and I've been measuring noise from events such as this for many years. And your figures didn't make much sense because you didn't give a time period over which you were measuring. Can you just explain to me what the time period was, please?
The time period would have been between every 10 or 15 minutes, and I took them all the way through the day. So during the when the band were playing, the whatever their name was, it would have been about every 15 minutes. And they say it was generally between 95 and 100 decibels at that point.
Alan, do you have any further?
Sorry, Chair. I'll be more clear on my question. Was it an LEQ? Was it an instantaneous noise level?
It's instantaneous. So we use this device and we stand and we look at it and then we record what it is on average.
So really, that's not an accepted way of measuring noise. We normally measure noise over a period of time. So, for example, my measurements would take.
This is not a point of clarification. You can certainly make that point, Alan, when you come to your presentation. I think if you've got, this is really a question rather than a statement of what is or isn't the case. So if you've got a further question, please ask it. But not.
I was asking a question of clarification on the noise levels because I think they're misleading.
Okay,
it's going to take you a while to explain that.
I don't think that's a fairness.
In which case, I'll wait.
That's not a question. That's a statement. That's not a question. But if you could try and ask a question, I'll happily allow it. But you need to ask this as a question, not as a statement.
Okay. Well, in which case, I'll wait to do my own submission to address all my points.
Yeah. Okay. Cool. Thank you. Right. Members. Any questions from there? If I look round, Councillor Johnson, any questions from you? You're on mute at the moment, Tim. Do you want to come off mute if you've got? That's it.
Sorry, pressed the wrong button. Apologies. Can you hear me?
Yes, we can.
Yeah, Rob, thanks for that. It was very detailed and very interesting, actually. Just one question. I take the point about the electronic drum kit. Have you specifically asked this for this event for the group to use the electronic drum kit?
Not for this event, no.
Okay, thank you.
I mean, that's right. They all say we'd like to bring our own drum kit, and my experience is it's just not worth arguing with them.
Yeah, but point taken, but you haven't asked yet.
No.
Okay, thanks.
Thank you. Councillor Patmore, Stephen, have you had a question from you?
No question, Chair.
Okay, thank you. And Councillor Hoskins, Keith, any questions from you?
Yeah, thanks, Ian. Hi, guys. So when the band books in, do you explain to them that you may have a problem with their drum kit?
Yeah, whenever we do music outside, we always explain that we have to be cognizant of the effect it has on the neighbours. I explain that we are working with North Lancs District Council on those limits, and I also explain that we have a HAPS limit of 100 dB inside, and should they at any point go over that, we will turn it off. We won't just warn them, and we haven't had an issue yet with any band. They've all been quite they're cognizant of the fact that we are trying to do it sort of properly here. So that's what they all get briefed beforehand, and we also tell them that if it's going to be too loud, they won't be able to play.
And how often do you do live music?
Outside?
Yeah.
We have a restriction on our license, which I didn't bring up today, but happy to talk about talk if you like. We're allowed to do 6 events a year.
Right.
And so there's a bit of confusion about what an event actually is, whether it's 96 hours or it's one day, but that's something we will resolve as part of this process going forward. But last year, for instance, I think we had 4 days of events, so not very often. And we're proposing again that we've actually got a list in our event plan of all the events that we'll be holding in the year to distribute to the neighbours and to environmental health as well. And it will be no more than 6 events.
Sure. Okay. Thank you.
And then just for myself, and Keith asked one of the questions just to understand the number of events you've had, and what complaints from directly have you had from neighbours in terms of any recent events that you've held, like the ones that you mentioned in your submission?
We've only had one event this year, and that was no, we had 2 Country Boots Baller Routes, but we haven't done any complaints. You know, the neighbours know to ring us up. We ask them to ring us up. If they ring us up, we follow the process, which is we have a log the details. If they give us their details, well, we'll log them. But we haven't had any. What the process is, if they ring up, obviously, apart from logging everything, is to try and investigate why it's so loud and sort it out, quite frankly. But as I say, we haven't had any complaints. What does tend to happen with two of our neighbours, and I should say a majority of those are quite happy, is they will log it directly with the council.
Thank you. I haven't got any further questions.
Could I ask one more? Sorry.
Yeah, by all means, Councillor Johnson. Go on, Tim.
Rob, So I'm sorry if it sounds like a daft question, but I take it the kit isn't mic'd up then generally, because
No.
nearly all the outside concerts that I've been to of this sort of level, you would have, you know, maybe a boom mic over the top or on the bass drums. But are you talking about purely like an acoustic sound from the drum kit?
The only bit we tend to mic up will be the kick drum, the bass drum, the big one. And the reason we do that is musicians tend to like that being put through the fold back speakers, which goes back at them, not into the audience, so that they can keep the rhythm going. The rest of it, if you're in a big concert, obviously you mic them up because they wouldn't be loud enough. But for us, they are plenty loud enough.
And are you confident you can regulate that? I mean, again, sorry, it's a daft question. I know you can turn it down, but is that not a possibility to have that drum bass mic down sufficiently?
Well, it's not loud. As I say, the only reason it's mic'd up is it gets folded back into the face of the performers, so that noise doesn't go forward into the audience. And it doesn't need to be loud. It just to be enough so they can hear it. So it's not loud. That's not the issue. It's the actual issue from the toms and from the from the snare and the cymbals. That's where all the noise tends to come from. And the cymbals tend to get soaked up quite well in that booth. It's the toms and the snare drums that's all the racket, to be honest, in a beautiful way.
Yeah. Okay. Thanks, Joe.
Thank you for that. I think it's on that basis. Thanks for that, and on those answers you provided, Mick and Rob. Let's then move over to Alan to present your submission to application. Obviously, we've seen the objection, but Alan, over to you.
Thank you, Chair. Yeah, as I'll just do a quick précis, similar to what Rob said, that the premises license for the Orange Tree was reviewed in 2021 by a member of the public, complainant, who was concerned about noise from previous events. That was before my time. But as a result of that, the committee decided to place a number of conditions, which Rob's mentioned, on the premises license, including an environmental management plan and this one which we have to agree noise levels. So in pursuit of that, when I arrived at the council, a meeting was held in November 2023 with a view to me offering my assistance in setting the levels with the premises. And I followed this up in an email in January 2024, reiterating that offer of assistance, but it was never taken up. Now, an event was held this year on the 5th of May under a temporary event notice, which wasn't objected to by me. However, what I did some measurements to try and stop the process of agreeing noise levels. And noise levels in situations like this, i.e. concerts, are dealt with primarily by local authorities and other events like festivals and such like, with the code of practice on noise control at concerts, which Rob Scahill alluded to. And in there, it grades events based on the number of event days per year and gives a level for them. So for example, 1 to 3 days is a less stringent target than more than 3 days. So Rob's alluded to the fact the license that he wanted 6 events. That means it goes to the third level, which is 15 dB above the background level. I measured the background level in one of the complainants' gardens as 43, which means the level that I suggested was 58. And clearly, when I measured this event at the complainant's house in accordance with that guidance, it was 69, which means it's 10 or 11 dB above where we need to be in terms of that guidance, which I've tried to explain to Rob, and I think he gets it. But quite clearly, if we're having a live band in that garden, we're going to be struggling to meet it, certainly with the drum kit. Now, the offer is still open to agree these noise limits. However, and licensing have put this in an email on 22nd of May to Mr. Scahill, setting out what we need to see in terms of discharging these conditions. But shortly after that email, the next day, in fact, this 10 application was received. And because we got no further in terms of agreeing the noise limits, I raised an objection. I raised an objection on that I can't be confident that the licensing objective to prevention of public nuisance is going to be upheld in this instance. To me, it feels like the 10 application route is being used to circumvent the agreeing of these conditions, such that we can the applicant can have, not the applicant, sorry, the DPS can have events without sticking to any noise limits that we've agreed. Just like to raise a couple of points that were raised at the last hearing, one of which was by Mr. Scale himself, which he said, I've written it down I've transcribed this from the meeting. He said that he knew pretty early doors that having a full band playing with drums and so on was just not going to be acceptable. I totally agree with that. I don't think this location is suitable for such events. I'm happy to try and assess that in the future, but that's my gut feeling at the moment. The pub garden, the marquee, is surrounded on at least 2 or 3 sides by houses. It's in the middle of a residential area. The closest of which is 2 complainants that I have, who I've spoken to this year, are concerned about the noise and wish to pursue some kind of controls on the event, which is what we've been trying to do. So that's it really for me. The point I'm trying to get to is to agree controls on the premises, which at the moment we haven't done. So these conditions need addressing before any further events are held at the premises, in my opinion. We need to do this by some kind of propagation test, not a live event. So we need to perhaps play some music at a time when there's not people waiting to hear music. So obviously that's quite intrusive in terms of an event. And we need to try and ensure that the prevention of public nuisance, the licensing director, the prevention of public nuisance is upheld by getting to the bottom of this agreement of the levels. So I'm happy to answer any questions or clarification.
Thank you. Thank you for that. Right, over really obviously to Mick and Rob, if you've got any specific points of clarification from Mr. Stone.
Yeah, I have a couple. I mean, the first one is, I did talk about it in my submission. The document he's referring to states it's specifically not to be used for public houses. Why does he think that therefore the levels in that document we should be cognizant of, especially bearing in mind the second document that I mentioned, where it talks about the fact that they couldn't agree detailed decibel levels in there either because of the complexity of this issue?
Alan?
Yeah, well, so point 1.4 in that document, Rob's referring to the statement which says this code is not designed to address the question of environmental noise arising from discotheques, pubs, and public houses. Yes, the key word in there is environmental. So the other document that Rob is talking about is the Control of Noise and Pubs Guidance, and that refers to the environmental noise that it doesn't deal with, which is the main sources in that document are music, internal music, singing, public address, children's play areas, beer gardens, people in general, car parks and access roads, deliveries, collections, materials handling. That's environmental noise, not noise at concerts. In this document, well, the Control of Noise from Pubs and Clubs guide at point 2.6 actually says this guide should not be used to determine or enforce noise standards for occasional music events of the type covered by the Code of Practice on Environmental Noise at Concerts. I go back to that previous document, the one that I think is appropriate and we use all the time for events of this nature. I go back to that document and it there's a glossary in that some definitions, at section 2, one of which is it describes a music event. And the music event is described as a concert or similar event where live or recorded music is performed by a solo or group of artists before an audience. Quite clearly, a live band in a garden is exactly what it's for, and even in a public house, and that's the document that Rob was referring to points them in that direction. So I maintain that's the right document to use.
Just for a bringing up, and I will make just a statement here that obviously it would be fair to say that and this is for the applicant and obviously for you, Alan. The panel here have not seen any of these documents. You've not cited them no one has actually provided this information from us. So that makes it quite difficult. This feels a bit like Rishi Sunak and Keir Starmer in throwing numbers and paragraphs around, which is quite hard for us to be able to determine because we've not seen any of this.
I completely appreciate that.
I'll leave that on the table for the moment, but I will maybe come back to that. But I'll allow Mick and Rob just to come if they've got any further questions. of clarity?
Yeah, I have. We have two more points. My first point is you did mention, I guess, before you were cut off about how we measure these devices. I use this thing. One of the things I'm looking forward to as we take this forward, I hope, is that for you to use your expertise and your equipment to help us with this determination of making sure that what we are recording is correct. Because without correct data at the beginning of this process, we're not going to get anything decent at the end of it. So I would like to, I guess it's a question is would it be pertinent for you to be able to come to this event and use that equipment just for the process of getting some real proper data for us to use in determining what the levels actually are going forward?
Alan?
That's me.
Yeah.
Yeah, sorry. Firstly, Rob, you haven't got a license for this event yet, given the situation we're in here. Yes, of course, Rob, that's what I said in November last year. That's what I said in January this year. And yet here we are 2 days before a proposed event, no further down the line. I've offered my assistance, and yet you haven't taken it. I had to come out on my own back to try and progress this matter in terms of setting the levels. I do my own monitoring at the complainant's house. I received no input from you. I received no contact from you in relation to this. I got nothing to my email in January. That's what's been quite frustrating. But yeah, of course, I welcome the opportunity, but I don't think we should do it at a live event. I think we should do it as a propagation test.
Okay, I don't think it's worth getting to a...
You have one more question.
Right. Do I get to respond to that or no?
No,
Okay.
you can respond to that because you'll have an opportunity at the end to respond to that. You will absolutely. This is really just if you've got any further questions for Alan. Anything further you want to ask Alan at this stage? But you absolutely can come back later on in your summary of.
No, that's fine.
Lovely.
That's fine. Thank you.
That's great. Thank you. Right, I'll go round the council room again. Tim, any questions from you?
I don't know if it's appropriate at this point, but the only question I've got is if this isn't granted, are you able to hold it inside? I'm not familiar with where you're sitting, but legally hold it inside. Although I appreciate what Rob said, Mick said at the start.
That's probably not submission. A question for okay. Alan at this stage, but we can pick that. That's probably not fair to ask.
I will say, can I say something? We did offer that as a solution to this problem. That just hold this event inside, have a barbecue outside, have the music inside, and people can go in and out as they please. That was a solution that we offered. But
that's sort of what I was getting at. But yeah, yeah.
Okay, I can answer that.
This is just for councillors to ask them. But I'm more than happy for you to respond to that at the end. If you could just log that thought for the moment, and we will make sure we let you have that opportunity to respond to those points. I will not forget that. Tim, any further questions for Alan at this stage? No,
thank you.
No, Stephen, anything?
No, Councillor Johnson asked the question I was going to ask, so I'm good. Thank you.
Cool, lovely, thank you. And then Keith.
Can I just confirm that we were talking about live music until 9 p.m? Was that the?
Yes, that's correct. That's
yeah,
correct.
Okay.
Yeah.
Right. Thank you.
Yeah. And so I don't know whether Alan, this may be an unfair question to ask, but I mean, if you're able to answer it, it would be really appreciated. When we talk about 58 decibels and 69 decibels, as you mentioned in there, if I was standing in my garden now, or if I was sitting listening to that music coming from next door, how much louder is 11 decibels? What would you feel like? I know this is a feeling rather than a scientific measurement, which is why it's unfair to ask you in a way. But I suppose I just really wanted to understand how different it would feel, those 11 decibels between the 58 and the 69 and so on.
There's two ways of explaining it, really, I guess. 10 dB difference is equivalent of double the sound power. That's a scientific answer, I guess.
Yeah.
In watts, double the sound power. In terms of noise levels, it's a significant increase. For example, if you had a stereo at 1 meter in front of you playing music at 50 decibels, where you measured it where you were hearing it, and then you placed exactly the same stereo next to it and played that one at 50 decibels, so you'd have two noise sources of equal volume, it would increase the receiver volume by 3 dB. So it's significant. So it's a logarithmic thing. It's a significant increase in noise levels. I'm not saying that 69. Well, it depends on the number of event days he has per year, and I didn't want to get bogged down in the guidance because I know you haven't seen that, and I think it's a question of the levels here. It's a question of, in my opinion, there's conditions outstanding on the conditions were placed on the premises license as a result of a hearing called by from a review called by a resident of the area who was bothered by noise. Conditions were placed on that premises license with a view to controlling the noise, and yet we're in a position here where by them conditions are going to be circumvented, but no controls are going to be applied again to another event. That's the crux of the problem here. We need the controls to be in place so everyone knows where they stand, both the applicant, not the applicant, so both the DPS, Rob Scahill, the residents and ourselves, so that they can tailor their events to their premises and that they can have events without fear of us coming and taking regulatory action against them for whatever reason. And that's so that we can allow them to carry on the business as they wish and to make money and entertain their guests and customers. Clearly, if we keep putting TENS in place to circumvent the conditions that are there to control the premises, then we're never going to get to the bottom of the problem. We're going to keep going and going and going. We need to solve the ultimate problem, which is we need to agree the levels. And I don't think we're going to do that today, like you pointed out. But that's something that me and Rob are going to have to work on and agree. Having said that, it doesn't stop our regulatory responsibilities either. We still have a duty to investigate all complaints. I've got 2 current ones, and I have a duty to investigate them.
No, that's fine. Thank you. That's helpful. Okay. Well, I think obviously we've heard from everyone, which I think probably moves us towards the sort of closing statements in terms of this part. So really over to the licensing officer for any final submissions or information they wish to make to the committee. And I think Mel, over to you.
Okay, thank you, Chair. Just to say thank you for everybody for contributing to this hearing. And in summary, it was a temporary event notice for a birthday party for this Saturday, the application was 12 o'clock till 10 o'clock at night with a DJ and band set to end at 9 with barbecue, invited guests only. Mr. Scahill presented on behalf of Mr. and Mrs. Curtis, gave an overview of the reasons for the application and stated that Mr. Curtis was also aware of the discussions already with the Environmental Health Officer regarding the licence that's in situ. Then Mr. Scahill presented his the backgrounds over the previous hearings back to 2021 and stated that they're working on an agreement to resolve the issues with the officers. This discussions are still ongoing, and that is definitely over the decibel levels. He said that the engineers are facing challenges. It all depends on the instruments. Drum kits are placed in booths to help reduce the noise, and has requested that they use this event as a real-time example. Then Mr. Stone gave a background over the incidents recorded and the status of his investigations, and still awaiting a closure on that. Just like to take a point that we do have some information in the sense of examples. We have things like sorry, I'm just going to try and refer to some notes here. So, for example, a jet taking off or outboard motors, power lawnmower, motorcycles, etc. there could be up to 8 times as loud as 70 decibels, which could cause serious damage, especially if it's up to like 8 hours exposure. So there are noise indicators available on the internet for reference to. I would say there is a right of appeal against any decision made by the subcommittee from this hearing today. Any appeals must be made to the magistrates' courts for which Stevenage is the area within 21 days. No appeal can be brought later than 5 working days prior to the day of the planned event, and the appeal has to state the grounds of the decision being appealed and accompanied by the appropriate court fee, and must be lodged with the clerk to the magistrates. Thank you.
Thank you. Thank you. Then really, I feel move to any final submission from the responsible authority. Alan, is there anything further you want to add at this stage?
Is this summing up, or is there anything I want to add
Yes,
to what I've
it is.
already
Yeah.
said?
Yeah, summing up.
Yeah, okay. I'll reiterate it again then, I guess. I object the conditions placed on the premises license at the hearing in 2021 were an attempt to place some controls on the use of the external area for music events. This control is circumvented by the temporary event notice process. Whilst 110 was granted earlier this year, I object to this one to ensure that the spirit of the license conditions and therefore the licensing objectives are upheld for the prevention of public nuisance.
Thank you, Alan. And then over to the applicants for any final submissions they wish to make. Mick and Rob.
Okay, thank you, Mr. Chair. A couple of things. I've said quite clearly that if we're going to have live music outside, then you need a drum kit. Drum kit is going to be loud. I said quite clearly, I think again, that if we're to follow the levels that have been set by Mr. Stone, we're not going to be able to have a drum kit. There's no point because those kind of levels are quite draconian, I would like to say. I'd also like to say that I appreciate that we have a marquee outside. This is generally as a result of COVID, when the government asked us to build outside structures to stop people coming inside and all that sort of things. It's quite expensive. I'm still paying for it and will be for quite a long time. But other pubs in the town now have the similar sort of structures outside and regularly use them for live music. And I've been to some of these events and they're certainly louder than we have at the Orange Tree. But if Mr. Stone is insistent that that sort of level is necessary, we have to stick to it, and that level then gets transcribed to other pubs.
I don't think we can. I really don't think we want to get into what may or may happen in other places.
Okay, but the point is, obviously, we can't have live music outside. Moving on to, can we have it inside? Well, of course we can. We have a different set of restrictions inside that we've proven over the past 12 years that we're very compliant to. Problem is, as Alan alluded to, you have people opening doors going in and out. It just defeats the object. I have an allowance on my license to hold an event inside with the doors open in the room where the band will be, which completely defeats the object. We might as well put it in the marquee, because we can do that with a loud band, louder than it would be outside. It's not about whether it should come inside, because also 60 people is the capacity inside of the van. It's about, can we please do this outside and use it as an opportunity to make sure our measurements are correct and use that to take it forward. Alan mentioned circumventing the licensing process. I was advised verbally by a North Arts District Council licensing officer to put temporary event notices in whilst this was being sorted out. I had hoped that we would have sorted it out before then. I did send a copy to licensing and to Alan of these proposals back on Monday. I haven't heard back at all. Finally, I just wanted to say that, you know, I believe we have to be compliant. It's really important to me, and I've been striving to be compliant since I took over this pub in 2010. What's important, I believe, is what the neighbours think about this, and they don't seem to have been involved, even though I have tried to involve them over time. And my question, or my statement, if you like, is, look, if the neighbours are happy with a 70 dB limit in their garden, however we define what that limit is, surely we don't have a problem here. If the neighbours are happy that that happens no more than 6 weekends a year, or less if necessary, which will be determined, I guess, at another hearing, then again, surely we're okay. Because what I get from talking to most of the neighbours, there are two that don't talk to me, and these are probably the ones that are making, as usual, making the noise. The rest of the neighbours are quite happy. In fact, one neighbour rung me up and said, the music's beautiful today. Please, can you do more of it? So we are trying to be compliant. We have an opportunity here to go forward and get that compliance without looking back and maybe argue about what has or hasn't happened in the past 3 years. So I'd like us to take the opportunity to let Mr. Curtis have his party, let the dirty half-hundred play outside, monitor it, record it as much as we can, in partnership with North Lancs District Council Environment Health if we can, and then use it to go forward and finally put this to bed. Thank you.
Thank you. I just before.
Oh, sorry, I did have one more point. I'm really sorry to butt in. I was talking at 73.6 decibels then. That's why I heard it here. So that's the level you would hear in a garden at over 69. It's not loud.
Yeah, I'm not sure. Yes, I'm not sure quite. That's completely relevant, but I understand what the point you're making. but yeah, can I just? I'm just before I bring our legal advisor in. Could I just check with the licensing team? Just obviously the applicant made a statement there. I just wanted to confirm that's correct. That the advice was that whilst this issue was being or still being resolved, the advice was given to the applicant to put a 10 application in. Is that correct? Is that from what the applicant has said, was on the basis that while the issue of the sound limiter and so on was being resolved, that they would need to put in this temporary event application?
Chair, that was not advised by myself. There are other licensing officers that have been involved in communications who are not present here.
Right.
But from myself, I know I didn't advise that, and I don't think my colleague also online did.
I don't know whether, Jasmine, are you able to comment on?
That advice was not given by me. No, as Mel stated, we do have another licensing officer, but no, it would kind of defeat the object of a condition if that were to be our advice.
Okay, the advice was given verbally. It's not on record. I can attest to it in court.
Okay, we can take that on board. Thank you. Right, which then moves us to a legal advisor. Simone, could I invite you to summarise any legal issues that have been raised at the hearing?
Take myself on mute. Ultimately, Chair, this application concerns a temporary event notice, and we are particularly concerned about a slightly narrow element of the licensing objectives. There is a particular focus in this case on the public nuisance limb of the 4 licensing objectives, which has been put forward by Mr. Stone in response to the 10 application. Of course, the panel is not limited to consideration of only that limb. There are 4 limbs under license objectives that were previously set out, and any that appear relevant should be considered and form the backbone of any decision. In considering obviously the sound levels, the panel are being asked to determine sound levels and whether the sound guidance issued back in 1990, which is a guide, and therefore you're not fixed to that guide, but it's one that consideration should be taken account of, and the panel's also required to consider local conditions. So it's very important to put some local context into that, and consideration probably, I would say, of the passage of time is also appropriate, given that the guidance hasn't been updated in excess of 30 years. Now, it appears that the applicant has put forward a condition of potentially 70 decibels measured as at the neighbour's garden. Of course, the panel can consider whether the imposition of any conditions would help to promote the licensing objectives, and if that is the case, the panel is entitled to impose whatever conditions it believes are not inconsistent with the licensing activities. The panel does not need the consent of the applicant for the conditions. They may put forward whichever conditions they consider appropriate, and it will be a matter for them to be met, or the applicant may simply decide not to go ahead with the event. Given that the thrust turns on the evidence and a consideration of sound levels, particularly important on the evidential basis that the panel, as you've noted, have not been provided evidence by either the parties. There's been extensive reference to data, but ultimately that's not been put forward to you. But the panel is also reminded that the licensing framework is permissive, and therefore the starting point is that activities are allowable unless the licensing objectives would not be promoted by allowing something to go on. And so finally, I ask the panel to have consideration to paragraph 9.44 of the national guidance, which is that the authority is shall to consider the potential burden that any condition would impose on the premises licence holder, such as a financial burden due to restrictions on licensable activities, as well as the potential benefit in terms of the promotion of the licensing objectives, and obviously consideration of whether or not the licensed premises are responsible or irresponsible licensed premises may be relevant. And you've heard some information about the number of events and the restriction that there is generally in terms of these types of events 6 times a year, as well as what the applicant has said about the age and the nature of the attendees that will be attending this event.
Thank you. That's helpful. Any members, any questions for the legal advisor at this stage? Tim, anything? I don't think Stephen, Keith? No, doesn't look. No, I've got no questions at this stage for the legal advisor. So if then I'd like to invite the committee member, scrutiny officer, to explain the next part of the process. Susan.
Thank you. The subcommittee will now be retiring to make a decision in private. Public viewing the meeting are welcome to wait and listen to the decision. However, this might take some time. Once the subcommittee has made its decision, this will be announced via the live stream. If members believe that the decision will take too long, to avoid parties waiting, they may decide not to announce the decision live today. If this is the case, an announcement will be made to this effect by the subcommittee and the meeting will be closed. The decision would then be announced in writing within 5 working days of this meeting. Members and officers will shortly be receiving an invitation to a breakout room. The applicants may stay or leave if they wish. A hold notice will be displayed in the Zoom call and the live stream will continue. Please note that as the live stream is ongoing, anything said during this time will be recorded. I'm just going to go out and speak to my colleague Chanel that's running the breakout room because I can't do anything else from here. So just stay where you are.
We just want to check that the applicant is still here and can hear us.
Yes, we can.
Lovely. Okay. Mel, can you still hear us?
Yes, I can. Yep.
Lovely. I'll hand back over to either Susan or Councillor Albert.
Okay, Councillor Albert.
Probably me, yeah, Susan,
Yes.
yeah, that's fine.
Over to you.
Good, thank you. Well, so
Sorry, can I just make sure Alan Stone's here as well? Sorry.
oh yes, yeah.
Yes, thank you very much.
Sorry, Alan.
Hello, Alan. Hi.
Hello.
Right. Okay. So thanks everyone, and thanks for your patience. So what I'm gonna read out a decision notice, but also there's also some additional advice which is not formally part of the decision that I'll also want to read out at the end. So decision notice, and you'll all get a formal written copy of the decision. Date of hearing 6th of June. Members of panel: Councillor Keith Hoskins, Ian Albert Chair, Tim Johnson, Reserve Member Stephen Patmore. Applicant's name Michael Curtis. Premises address the Orange Tree, Norton Road, Baldock, including the garden and marquee area of the Orange Tree Public House. Date of application 23rd of May. This is an application for a standard temporary event notice under Section 100 of the Licensing Act 2003. The subcommittee has read the material presented to it and has listened to all the evidence and submissions. The subcommittee has considered the national guidance, December 23, and the statement of licensing policy, and has come to the following decision: that the application is granted. The subcommittee recognises that the conditions to attend can only be imposed in the circumstances where all the following conditions are satisfied. Relevant persons objected to the 10. The objection has not been withdrawn. There's a premises licence or a club premises certificate in relation to at least part of the premises in respect to which the 10 is given. The subcommittee considers it appropriate for the promotion of the licensing objectives to impose one or more conditions, and the conditions will not be inconsistent with the carrying out of the licensable activities under the 10. Subcommittee considers that on the admissible evidence received and representations made, no conditions are appropriate for the promotion of the licensing objectives. Conditions are proposed by the responsible authorities as none. Conditions proposed by the applicant as none. The effect of failure to comply with any of the conditions attached to the 10, and obviously you see that in some detail. I won't read out all of that. Statutory guidance considerations, again, obviously subcommittee has taken into account the revised guidance issued under Section 182 of the Licensing Act. There's a number of paragraphs there. You can see that in the written statement. Subcommittee has taken into account the North Hertfordshire District Council's statement of licensing policy in reaching its decision. Again, there's a number of key paragraphs that we've listed there. Rationale for decision. The subcommittee considers that the application for the 10 should be permitted to the extent outlined above for the following reasons. The time for the event proposed appears proportionate. The fact that it is a private event gives confidence that the likelihood of public nuisance and crime and disorder is low, and the existing condition of 6 events a year on the premises licence means that there's a fair balance between the role of pubs in the local community and promoting the licensing objectives. This is only the second event in the last 6 months. The 10 should come into effect on the 8th of June. It will end on the 8th of June. The applicant may appeal if the decision of the subcommittee is to give a counter notice. The appeal gets the counter notice and is to a magistrate's court. And again, obviously, you can read the detail of that. The relevant person may also appeal in circumstances where the subcommittee decides not to give a counter notice. But however, no appeal may be brought later than 5 working days before the day on which the event specified in the 10 begins, and clearly, obviously, colleagues will know that's itself an issue. But obviously, the application is granted for the reasons I have stated. Now, I do want to also then to come to the additional advice here, and obviously thank all the both. Obviously, Alan Stone and the applicants for their attendance today. It is appreciated, and we know that everyone is doing a difficult job here, and obviously it's really important for us to listen to all the evidence that you should bring. Now, the advice is separate, but this is the advice. We do think that it would be helpful if Mr. Stone can attend the event at the weekend to gather evidence that the authority can use for context and for future applications, as the guidance to sound levels is very dated, and we believe that evidence will be helpful in looking at any future applications. If an objection is put with supporting evidence by Mr. Stone, or any relevant objection that the Orange Tree is using the TENS procedure to circumvent the conditions on their premises licence, this may give grounds for any future panel to determine that they are not a responsible premises licence holder, and therefore granting the application may not promote the licensing objective. I think it's clear, obviously, here that we do want to see that outstanding issue resolved, and we don't believe actually that producing further TENS is the right way forward. And that's why it's really important to get this resolved as soon as possible. In addition, though, the panel expects parties to file supporting evidence. There is limited weight that can be given to oral representations, and it's particularly important that anyone objecting files evidence, given the starting point of the licensing framework is that the licensing is a permissive regime. And I think that's why the evidence gathering at the weekend here is, I think, really critical. But as I say, we do think it's important that we want to get this that long outstanding issue resolved, both in terms of for the applicant, the licensee, and obviously for the neighbours in the area. It's important that we try and resolve this and get this people working together in a way that benefits the whole community. That's the end of the our advice. I'd like to thank everyone for their attendance today. I hope the event goes well at the weekend. I thank obviously Mr. Stone for his participation and obviously providing all the information and technical advice to us today. And I do hope obviously we can obviously look for ways that we can resolve this long outstanding issue. But I thank everyone for their attendance, committee services for their support, and obviously our legal and licensing teams for their hard work. And I thank you and wish everyone a really good afternoon. The sun is just about shining, so please enjoy the rest of your day. Thank you, and thanks for attending the meeting today. Thank you.
Thank you.
Thank you.
Thank you.
Bye then.
Bye-bye.
Thank you very much.
Bye then, and thanks.